think we should start while other people join. Good afternoon, everyone. My name is Iain and I'm the head of the law school. I'm so delighted today to welcome you, welcome all of you, and more importantly, to welcome our distinguished speaker of this year's Melland Schill lectures. Melland Schill lecture is a series of prestigious lecture in international law that we've been running. Melland Schill lecture was running until sometime in the mid-2000s, and then it started again in 2012. And we have been having prestigious speakers to give a lecture, to give talk on different aspects of international law. And this year, we'll be having Professor Martti Koskenniemi, who will be giving a talk actually based on his most recent book, which was published last year. And the title of the book is To the Uttermost Parts of the Earth, Legal Imagination and International Power. That is 1300 to 1870. So it's actually Martti has looked at international law, the imagination and international law thinking for many years. I'm tempted to say I will introduce Martti. In fact, Martti is somebody who doesn't really need an introduction, but I may just say a few words to kick things starting. Professor Koskenniemi is the professor of international law at the University of Helsinki, and also the director of the Erik Castrén Institute. And Professor Koskenniemi has not just been writing international law books, he's also been involved in the diplomatic service, because between 1978 and 1994, Professor Koskenniemi worked in the Finnish diplomatic service. And during that time, he was also counsel to the government of Finland in a number of cases, and one of the most famous one being the passage through the Great Belt. That's the Finland against Denmark between 1991 and 1992. And he was also the member of International Law Commission between 2002 and 2006. Professor Koskenniemi has been visiting professor to so many universities around the world, including the New York University, Columbia University, University of Cambridge, London School of Economics that I know Martti visit very regularly. And he has also published so many different books. I will just mention some of them, some of them that have personally have really interested me. I've really read those books with joy, because one thing with Professor Koskenniemi is that his style of writing is critical, but when you hold the book to write, the storyline flew so smoothly that it's very difficult to be bored when you read the story. So I remember when I was doing my PhD, anytime I would get bored with what I was doing, I would pick up one of his monographs and read, and then it re-energized me. So some of them include From Apology to Ethiopia, the Structure of International Legal Argument. That was the one that really moved me that I used to read. It was first published in 1989, and it was republished again with the epilogue in 2005. And then there was also The Gentle Civilizer of Nations, The Rise and Fall of International Law, 1870 to 1960, which was published in 2001. And then the other one was The Politics of International Law. And today we'll have him talk about the recent one, which is To the Uttermost Parts of the Earth, Legal Imagination and International Power, 1300 to 1870, published last year by CUP. I can go on and on and on with the introduction of Martti, but I think I will spare you that time, and we'll listen to this very interesting talk by Martti. So Martti, the floor is yours. Thank you so much for coming. We're so delighted in Manchester to welcome you. We hope, we wish you could have done this face to face, but anyway, it is what it is now. But hopefully, I'm still really looking forward to having you face to face in Manchester in the near future. So thank you so much.
Thank you so much, Iain, for that lovely introduction. Yes, it's great to be in Manchester, although it's kind of crazy to say it, because here I am in Helsinki in my study with the mermaid that I got from my granddaughter a week ago or so. But, you know, it will last as long as it will, and then we'll see each other in these rooms face to face again. But it's great to be here, and I know that the worst thing to begin with is to begin with by an apology, but I apologize for using this occasion to kind of market the book that I published very recently. It's not just a book talk, though. I tried to expound and explore some of the ideas that I put forward in the book about what legal imagination might be, how to think about it, and how we can see it operating in the history, but also maybe in the present. So let me start by trying to share the screen with you. I hope this works now. Okay, so the title of this talk refers to the power of the legal imagination, and it's not just a metaphor for something. I like to think of the work of the lawyer or the work of somebody having to operate with law as a work of imagination, but it's also the work of imagination that operates within the confines and as a form of the use of power. And I think law's power through the imagination works in two ways. There's the framing power of law that we don't usually think about. So that's the power of law to frame the contexts in which human relationships exist and in which we exercise relationships of hierarchy, contractual relationships, and so on with each other. The most important framing devices that law uses are sovereignty and property that split the world in a very specific ways. And I wanted to explore how that operates, in fact. And the other power that I'm interested in is asserting power, or the power of articulation. When somebody speaks law, when we speak law, then we assert power. It's a power that comes from, not from ourselves, but it comes from law. It comes from the factuality or the factoid nature of the assertions that have a legal form, and that the impression that it's facts, it's something objective that speaks, comes from the competence of the legal native language speaker. So we yield in the legal world, in conflicts, in struggles between ourselves, we yield to the kinds of assertions that seem to have been made by competent native language speakers of the law, where they assert power. I'm not going to theorize more about this. I am just going to go very rapidly through what it seems to me is somehow very crucial aspects of the legal history of European uses of power. And in order to think about where it all starts, what other place can there be than the Bible? And of course, the Genesis is where everything begins. And here is a famous statement from the Genesis, which has been, of course, endlessly quoted, but importantly for my purposes, at least quoted by Francisco de Vitoria, the Spanish Dominican in the early 16th century, when he was thinking together with his students at the University of Salamanca about how is it possible that his king or his ruler, the emperor, Charles V, can assert power in the Indies. The statement from the Genesis is, of course, this: then God said, let us make mankind in our image, in our likeness, so that they may rule over the fish in the sea and the birds in the sky, over the livestock and all the wild animals, and over all the creatures that move along the ground. So here, God pictures human beings in his own image or her own image. That is to say, this is the view of the Imago Dei. When God is Dominus, to be created in God's image is to be a Dominus as well. And so our role in the world is to be dominant over fish in the sea, the birds in the sky, etc., including over the world itself. The world in Genesis, as the theologians in Salamanca and all over Europe and the Christian world understood, was donated to human beings in common. They dominated over the world in common. That was the essence of their being the images of God. Now, the theologians in the early 16th century Spain were the great intellectuals of the Holy Roman Empire. They worked as confessors, not only to Charles V, but to the Spanish nobles, the Castilian nobles, but also nobles and merchants across the Habsburg realm. And two questions arose in the context of confession. One was the question regarding the power of the emperor over, well, Castile. The Spanish nobles were not too happy that this Central European person from Burgundy came all of a sudden to rule over them, even though he didn't even speak Spanish. What was his rule based upon? And then the question, the pressing question regarding the constant expansion of trade. The production of silver in the mines of Potosi and elsewhere in South America created a boom, an economic boom in Europe, and great riches spread from Spain when the Spanish king was paying his creditors in Germany and in Italy and elsewhere, and making the wheels of commerce run faster, as Ferdinand Braudel has put it. But the church, of course, was critical of usurious purposes of merchants. So what about the right to buy cheaply in order to sell dear? I make these points in order to lay out the fact that the leading intellectuals of Christianity were faced with two pressing questions. How does somebody rule over other people? And how does somebody make a claim over stuff in order to exclude everyone else from that stuff, if it's true, as the Genesis teaches, that the world was given to human beings in common? And so at Salamanca, the Spanish scholastics developed on the basis of their readings of Thomas Aquinas, a Christian Dominican clergyman from 13th century France, as well as from Roman law, the Corpus Juris, a view regarding the division of dominia, and that there were two ways in which humans, in using the freedom that was embedded in their sense of there being a domini of themselves, using their freedom, had divided the common heritage that God had donated to them. On the one hand, they did this in order to create communities, and in those communities to choose a person to be hierarchically over them and rule over them. They call this dominium jurisdictionis, a specific type of dominion. Then there was another thing. There was the division of things, and the Spanish scholastics the great realists as they were, looked into the impossibility of owning things in common. If people own things in common, in practice that leads to only some people working, whereas others will just enjoy the fruits of their labor, and this will lead into endless strife. Therefore, being reasonable persons, human beings divide properties and create private property, which they call dominium proprietatis. So here is a framing created by the Spanish scholastics for important activities, important forms of use of power in which Europeans were engaged. And they asserted these terms, that they used this language in the context of confession. Charles V was a conscientious person, actually worried about the justification of things that he did. His war with another Christian prince, the King of France, as well as the question of his power over Indians who had never agreed to come to his power. And then the question of usury. How is it possible that one can use private property out of in a situation where God had donated this world to humans in common? Now, from the Spanish scholastic, this type of Christian framing, legal framing among Christians, then of course proceeded with Protestants, with Hugo Grotius, with whom, however, the justifying power of religious language had already lost its oomph, had no longer credibility, largely owing to the casuistry that had been created by late scholastics and especially the Jesuits. So science, the natural law, the natural lawyers, when they started out, decided that we would have to find the authority for our statements no longer from theology, but from science. And the science of man is the science of understanding how human beings operate. What is a human being? And Grotius famously, in the preface for the De Jure Belli Ac Pacis, argued that the one thing we know about humans from their early lives on, the relationships of babies with their mothers, was that they are sociable. They need each other. They have appetitus societatis. And with this construction of the nature of human beings as sociable, Grotius argued that the rebellion of the United Provinces against the Habsburg realm in the middle of the 16th century and onwards was justified because the king, in trying to convert his Protestant subjects into Catholicism, had broken the bond that should exist between humans, in which we sociably accept the ways of life in different communities, which leads to the understanding that the Protestant community of the United Provinces is a political community and a state. The second concern that Grotius had was, of course, the justification of the East India Company's trade in the Moluccas and in present-day Indonesia and Malaysia, and he undertook this in the context of war against Portugal. And there, the rights of the Dutch East India Company were rights of trade based on this idea of sociability, which is in human nature. The claim of monopoly by the Portuguese was a violation of the very nature of humans as creatures that want to exchange things with each other as an aspect of their naturally sociable nature. Now, everyone in the scientific naturalist project didn't think that the most important quality of humans was their sociable nature. I mean, how could you actually think that? If you looked around in the world, as Thomas Hobbes did in England, you realize that sociability is certainly not the only one, but maybe not even the predominant human quality. And instead Of course, in Leviathan and in his other writings, Hobbes famously argued that human nature is violent, fearful, and the nature of society, the natural society, is one where life is nasty, brutish, and short. That understanding of human nature is nicely present in an early English case, the ship money case. Actually, the ship money case, which Hobbes knew and the argument of which he adopted in Leviathan, where the question arose about the powers of King Charles I to tax his subjects outside Parliament. Now, of course, under the British or the English constitutional theory, no taxation without representation. So Parliament had to accept all imposition of taxes. The king, however, didn't want to go through Parliament. He was in dire straits. He lacked money to keep up such a life and such a court as to which he had been accustomed. And so he made the argument that England is threatened by an attack from Holland, and that the English fleets are insufficient to deter that attack, and therefore a new tax, namely the ship money, should be enacted. Now, many of the nobles protested against this. Some of them were arrested, and the ship money case arose, in the context of which the judges were able to formulate a doctrine that nicely frames the relations between those two large vocabularies through which in Christianity we justify the exercise of power, namely sovereignty and property. Here is what the Court of Exchequer said: the public and the private are so nearly connexed that they can hardly be separated. The public loss falls immediately as a consequence upon particular persons. Therefore, it's impossible for private fortunes to prevail if the public is lost. In other words, the king's power to protect the public realm overrides private rights, so that if it's true, as under the royal prerogative it was true, that the king's power extended to determining what's needed for defense, and if it's true that defense is ultimately directed at protecting properties, then the king's right over the king's prerogative overrides whatever private rights exist under the common law. Again, this is as an example of how the framing of a public realm of dominium jurisdictionis and a private realm of dominium proprietatis constantly operate in tandem through the imagination of judges, as in the ship money case, or legal intellectuals, as in the Spanish case. Now, Grotius had already tried to imagine the East India Company both as a private company, it was a joint stock company, as well as a representative of the United Provinces in his argument in the Amsterdam Admiralty Court in defense of the East India Company's war in the Moluccas. He said this is a just war because the East India Company protects its private property rights, which are based on the idea of sociability, as well as it's a just public war because the East India Company can be imagined as a representative of the United Provinces itself. The same construction appears in the charter of the Virginia Company in 1606. And I've quoted the original charter as well as the second charter that lays down the powers of the company. Here, of course, England, which was a really poor state at the time, was expanding in the east coast of North America. The Jamestown colony had been set up, and the question was, how do you rule over Jamestown? And the first charter given by James I, but actually drafted by Sir Edward Coke, no less a lawyer than the father of the common law, created a feudal arrangement with which he imagined that the Jamestown colony and the Virginia company would rule the territory that they have. The king will have all the lands. All the lands will be held by the king, but held in a specific way, held as of our manor of East Greenwich in the county of Kent, in free and common stockage only, and not in capite. Now I have to say that when I first came to this formulation, I thought that, oh, this is it. I can't continue any further. I can't make heads or tails of what this means. But to make a long story short, then of course one reads more, and one realizes that this is it's a feudal formulation, obviously, where the dominium directum is with the king and the dominum utile is with the company, but in a form in which the company owns the land in the form that's widest. In its widest form, that territory can be held by anyone under the dominum directum of the king. So in practice, ownership as it can exist in a feudal arrangement, although calling it ownership would of course be anachronistic. You can't separate sovereignty and property in this case. In 1609, because obviously the formulation was general and controversial, the powers of the company were detailed so that the company would have, and this is the latter statement, full and absolute power and authority to correct, punish, pardon, govern, and rule all of our subject of us according to such orders, etc. So the company is the sovereign, is the owner. Which one, we don't know. In the 18th century, a new development sets in. Emer de Vattel, as a natural lawyer in 18th century, and natural lawyer and a diplomat and a legal advisor of a number of noblemen as well as kings, in his Droit des gens, Law of Nations, for the first time imagined Europe as a system. And he imagined the states of Europe to exist like these great individuals, and extrapolated from the treaties that he read the idea that they among themselves were in a balance of power, and that the balance of power was the only natural way in which the state of peace could exist in a prolonged way between those European states, those grand individuals depicted rather in a Hobbesian, with Hobbesian attitudes towards each other, balance of power. During the 7 Years' War, that Vattel had written that treatise, the British succeeded in sinking much of the French Navy, especially when the French ships were sailing towards the Caribbean, the colonies in Caribbean, Saint-Domingue above all, which from which the French government got these great riches and the great amounts of sugar that made by far the most of French exports then forward. And the French were outraged. And the French government sent a diplomat, Maubert de Gouvest, to speak to Frederick II of Prussia in order to persuade Frederick to become French ally. And Maubert and the French ambassador was expected to say to Frederick that Britain was breaching the law of nations by sinking the French ships, because the balance of power prevented somebody from using their advantage or their superiority in trade matters over those in an inferior position as far as mercantile practices or maritime trade is concerned. The legal advisor, or the prospective legal advisor as he then was, to King Frederick in Prussia, Johann von Justi, wrote in response to the French dispatches this little book, The Chimera of Balance of Power in Trade and Shipping. And in the heart of this book, written by a really famous German natural lawyer, is the argument that the balance of power is fine if you think in terms of political relationship between Europe, because you can measure the powers of the military, the way the military resources above all have been divided between European nations, and you can manage that. But then against that political arrangement, there is economy and trade, and you cannot balance trade. The idea of balance of trade, which the French were pushing forward, is ridiculous, because every nation tries to send its businessmen, as Justi puts it, every nation tries to send its businessmen to all the nooks and crannies of the world to make as profitable deals as possible. And to demand them from refraining from doing that would be wrong, not only for them, but for their business partners who also believe they are making profitable deals when they are trading with the successful mercantile nations. And so the distinction between political rules and rules within the economy, the political rules based on sovereigns who are supposed to be as equals towards each other, and the rules of trade and commerce that are supposed to be universal and non-regulated, was expressed in this exchange. In the 19th century, the international law that we now know was not yet quite there. Instead, the world was very largely ruled through British imperial power, as well as the emerging imperial position of the United States. In the Don Pacifico case, Lord Palmerston, the British Foreign Secretary, spoke to the Parliament in these famous terms, which suggested that the rule of law in the world is an extremely valuable quality, but it is a quality that's based on British rule and British protection of British interests. The terms in which he put this are, of course, famous, where he compares Britain to Rome in the days of old, where Romans could say civis Romanus sum, and he then suggested that every Briton, wherever they are, should be able to say the same thing. So this is based on the idea that there is no overriding international order outside the imperial order, where a privileged group of British citizens will always be, their legal rights will always be guaranteed through the sovereignty of the British Empire. Slightly earlier, Joseph Story, the famous Supreme Court member and author of the commentaries of American law, was despairing when he looked out of the United States towards the Atlantic or towards the Pacific. He saw no law. And so what he wrote was that without some general rule of right or obligation, intolerable grievances will grow up and weaken the domestic relations, as well as to destroy the sanctity of contracts and the security of property. So you can see that for the emerging commercial and industrial superpower, the United States, the great concern was that in the international world, in trade relations, the sanctity of contracts and security of property cannot be guaranteed owing to the absence of a overriding legal order. However, Story continues from this point onwards comforting his readers, saying, well, it's not actually this bad, because in every country there are courts, and those courts together form, under their national laws, they form a network of legal actors through the universal principles of contract and property can be realized. And so in the 19th century, the framing from London, from Washington, looks very different. There is, in the one hand, there is an imperial order in which sovereignty rules over the property rights of Englishmen above all, but also, if I had the time, I could elaborate on the very idea of rule of law in the imperial constitution. And then in the American side, the concern over private rights, security of property, etc., and the emergence of the idea of private international law as the code of global law. Now, here is the first intelligent framing of modern power. Hegel was many things. Above all, Hegel was the keenest reader of Adam Smith and The Wealth of Nations. And he took from the analysis, from the historical analysis, the four stages theory of Smith, the idea that it's a defining characteristic of modernity, that civil society becomes more intense and grows wider and wider, because the natural element for industry is animated by a push outwards to the sea. And in pursuit of this gain, where commercial relations gradually expand, dangers emerge, and the commercial life embraces elements of fluidity, danger, and destruction. And in the elements of the philosophy of right, Hegel, in a number of passionate sentences, describes the situation of the industrial worker in modernity, the pathetic position of the industrial worker. And he worries, obviously, over the destruction of society created by the expansion of commerce, trade, the intensity of civil society relations. And he juxtaposes to them the idea of the state. The state is the rational element that consolidates developments in civil society and prevents that final destruction that is such an important element in civil society developments. The state is rational, and its nature is to be universal, not in the sense that there would be a world state as Kant had foreseen or predicted, but in the sense that the states form as communities a world of universal right to the citizens. Now, in a sense, that understanding that there is a civil society, and the civil society is expansive endlessly, and that there are these states that contains a universal form, a universal frame for directing and controlling the developments in the civil society, of course, became the heart of the interwar, imagining that the nations arising out of the First World War tried to push forward in order to prevent the thing that had happened ever to happen again. So on the one hand, there were the public law institutions based on sovereignty, the League of Nations above all. Those institutions would, on the one hand, authorize the operation of sovereignty, as well as lay down specific limits in the covenant for what sovereignty can possibly attain, whilst on the other hand, free rein was given to the governmental management of protectionism vis-a-vis free trade. Of course, industrial expansion continued. Many countries were wishing to recreate the gold standard of the pre-war period. the financial fluidity, the investments that became intensified and in the end led to protectionism and collapse. The follow-up to that is the 1950s imagining of a world where sovereignty and diplomacy, the idea of public law as a rule over the world in general, was allocated to the United Nations. Obviously, that's where sovereignty is declared. The universal organization is based on the idea of sovereign equality of all of its powers, all of its members, and the members obviously have to respect their respective sovereignty and refrain from violating it. On the other hand, here in the image, the early steps of the GATT arrangement and the Bretton Woods arrangements, that's supposed to operate as a fixed trade regime in contact and an institutionally created trade regime, in contrast to the anarchic economic world of the interwar era. And between them, the important boundary between the sovereignty that enjoyed by individual states and the global trade system, which is the concern for the development. This person here is, of course, Mohammed Mossadegh, who nationalized the Anglo-Iranian oil company in 1951, which then became the starting point of the process that led to the drafting of the International Center of the International Convention on the Settlement of Investment Dispute and the establishment of the center in 1965, and which now has grown into the system of bilateral investment treaties and investment arbitration, over 1,000 cases. Today, those cases being the boundary or the touching point, the collision point, and the platform for the struggle of sovereignty on the one hand and property on the other hand, that which is confined within the nation and that which moves about universally. So this is the last slide, and it's a slide that inquires, or with which I want to inquire about legal imagination today. So many of the lawyers feel nostalgic about the 1950s regime, or the regime that was built at the time, the Cold War period, the way in which framing the political and economic issues was relatively simple. People knew their place and the tensions were well known, as well as the institutional mechanisms for mediating the tensions and operating both at the national and at the international level. So, of course, in the early 2000s, the question of fragmentation arose. Behind it, the idea that there is no clear idea of statehood or sovereignty that would be independent from the ways in which the resources of the state are being allocated, the ways in which property and contract operates so as to create wealth or allocate wealth and economic vulnerability between places. It's not only an economic set of concerns and arrangements, however, it's also concerns and arrangements with regard to human rights, with regard to the environment, with regard to criminal activities, with regard to security, and so on. You know, they'll know this story. So my suggestion is that the legal, that it's a particularly fluid moment at present, in which the frames within which legal imagination operates have become much more kaleidoscopic, as perhaps in this Kandinsky image, and in which the possibility both for worse, as we can see in Ukraine and in other places today, as well as, I think, for better, are available. The assertion of rights meets an assertion of rights without a clear system of adjudication between those different systems of rights once they emerge and find their frame within separate systems of legal arrangement, legal regimes, and so on. So I wanted to bring the latest work, the uttermost parts of the earth, to the present with these reflections that European power for a series of centuries, for almost half a millennium, has been framed within the confines of an idea of dominion, that was divided into two early on, namely dominium jurisdictionis, public power, the power of the sovereign, the vertical power between the community and the individual, and dominium proprietatis, the horizontal power between the contract partners, the economic power, and that those have moved in the course of the centuries in different ways. Sometimes sovereignty has been imagined as the superior concept, endowing or donating property rights, the content that they have, and declaring what those limits are. And sometimes, again, the other way around, property determining to what extent sovereignty can exist in a conflictual world, and what position sovereigns may imagine that they enjoy in regard to their colleagues. I think that some of that world has been exploded by the intense interest in the various activities that undergird the legal regimes within which legal competence is asserted and rights are asserted, and within which other people yield to those rights if they feel that the claim has been made in a competent fashion. So I end there, and thank you very much, and I look forward to the Q&A.
Okay, thank you, Martti. You've taken us through 700 years of legal imagination in a very clear way, in a way that only Martti can do that. So thank you so much. We have now two people, Iain and Gail, that will give some comment, 10 minutes each. But I will advise everyone, if you haven't read this book, I mean, have a look at it. If you're writing something which is completely not related to this book, just pick a piece of this book. It energizes you. I think the kind of energy that it gave me when I was doing my own writing, and even now when I do my own writing, you have the same energy. Just the way that Martti tells the story. I mean, it's a complex story, but he tells the story in a very clear way, in a way that you see the story actually like playing into today's world, especially with what is happening now between Russia and Ukraine. So anyway, I'll pass the floor to Gail, and then for 10 minutes only, Gail, I will be straight, and then we'll go to Iain, 10 minutes only, and then afterward there will be Q&A. We'll go back to Martti and then Q&A. Thank you.
That's great. So thank you so much, Iain, and thank you very much, Martti, for your wonderful talk this afternoon. In many ways, it's actually a good thing that we aren't doing this in person, as both Iain and I are currently in isolation with COVID, thanks to the ESA Research Forum in Glasgow. So I will enter as a little bit of a disclaimer that I do have somewhat of a COVID brain. I have this brain fog. And so maybe what comes now is a bit of a muddle of thoughts. I feel like if you treat it as a TikTok, like a series of TikToks, it might make more sense. But this is one of the problems with COVID. You never seem to be able to focus on something for too long. And we were also so pleased that you could do this talk this year, Martti, because we were reading to the uttermost parts of the earth in our reading group in the Manchester International Law Centre. And we had many interesting discussions and reflections, not just amongst the international lawyers, but also with legal historians and public lawyers in Manchester. And a number of recurring themes came up in our discussions. I'll never do them justice, so please, everyone do chip in and ask your questions or make your comments. You can add them to the chat or raise your hand at the end when we open up to the floor. So today I wanted to reflect, hopefully very briefly, a little on the theme of power, how we imagine power, people who use power, and those who exercise power by creating grand narratives about power. Because as we've heard, the book, or I call it a tome, and the lecture we've just heard is a history of the legal imagination as it operates in relation to the use of power. And the narrative is mostly of European white men and how they use legal vocabularies that is available to them to react to important events of their day. For this, our esteemed speaker today uses the term bricolage to describe how these men would employ legal vocabularies that are lying around to construct responses to new problems that may operate as a way to justify or to stabilize, as well as critique uses of power. And so this imagining of how power is wielded as bricolage can make, I think, the exercise of power seem more real and more tangible and more accessible. It almost gives you a taste of the mechanisms of how they exercise power. And it also came across to me as something almost quite pathetic. Sometimes you wish or hope there is a grand plan out there, but in reality, politics and the exercise of power is quite often this. And having been on the inside of this, I see quite clearly how often politicians or decision makers of the day pick up terms and the languages we use to redeploy them in favor of their own agenda. And we see that with greenwashing today. But while this imagining of how power is wielded is powerful in some ways, somehow I was wondering whether it was also a little bit misleading, because at the same time, clearly power is also something that is inaccessible to the many and intangible for many, given that we can't all rock up and do the same thing as Vittoria, as Kant, as Montesquieu. We just don't have that power because of certain structural and systemic privileges, such as our educational background. Nor can we ignore the constraining knowledge, background knowledge that informs whatever we're trying to do when we're trying to create something new. And this is something that Martti in the book recognizes when he says that the frame is constituted in part of what the lawyer or the political thinker learned during formal education, in part of the accumulated experience that forms the general sensibility of people and their consciousness of the world and of their place in it. So it's not just randomly people picking things up that are already lying around and throwing it at a wall to see what sticks. And what sticks goes down in the history books with the bad writing and the bad ideas tending to disappear. And this is something I think that Martti very much says in the book. But it's maybe for this reason that I wonder whether the bricoleur imagining does its job. And I do this for maybe two reasons. First, maybe these men were often also engineers, as opposed to the bricoleur who makes with whatever is at hand. The engineer is more the scientific mind. They'll try to deal with more discrete projects. They'll plan their projects based on available resources and available materials and create new tools to use in the construction of their projects. So it's a much more thought out enterprise than the bricoleurs. Now, these are two opposites. The bricoleur, the engineer ideas or totalizing ideas, as Derrida would point out. And so I think it's very much likely to be more of a spectrum with no sharp distinction. There is a scale in any one person, maybe shades more bricoleur or shades more engineer in different aspects of their life. But the engineer wants to create stable systems, and we see this in how many of the men did want to construct grand narratives of power and international order. And we see these stories throughout the book. And they used their education and for the engineer is educated while the bricklayer rarely is. And they created and deployed tools like sovereignty and property, and also new ideas such as the rule of law, not in a random way, but in order to achieve very concrete agendas at times. Thus, I think the engineer and the bricklayer are both useful to understand this wielding of power, although I do think that such a move would weigh down a book such as this by trying to bring in too much of this discourse or these ideas. Now, I said I had a second point about whether the bricklayer does its job. And this, for me, is maybe the more important of the two. So if the bricklayer is something of a romantic image, its opposite is this engineer who is rather dry, he's rather dreary, and having no sense of fun or play with their work.
Who are we inside Chile? We are intercultural.
This is definitely not me. Let's see who I need to mute. There we go.
Sorry, could you
sorry.
mute? Yes. Yes, go ahead.
Yeah, don't worry, I've done it. So where was I? Yes. So these two characters tell us something about how we imagine those responsible for exercising power, also how they ought to be held accountable, how we imagine the use of language, of concepts and of ideas, and how we imagine their deployment in the exercise of power. And I think how we think about this also says something about their implications, in particular, our understanding of their contribution and maybe even blame for the final outcome. And I fear that the idea of a bricklayer somehow lets them off the hook, somehow, as almost accidents of history. And so this is why the idea of there being a scale between a bricklayer and an engineer is sometimes a helpful, well, for me, a helpful way of understanding the wielding of power that's been very much brought to light from Martti's book. But the idea of the engineer as a scientific mind brings me to another point, which is how through this book we see the emergence of the rise of social science and the scientification of the exercise of power, if that's a word. Because we apply to concepts such as power our background assumptions about the world that are very much pre-constituted. And whether we want to think differently or not, the age of the social as science informs much of our discourse and our thinking today. So critiquing power in this way, we can see how it is used in conversations then and now, often as something that has a balance point, as an equilibrium, as having an equilibrium. And to me, this is then completely riddled with scientific, measurable thinking. The ordering of powers into the great, the middling, the free riders, or the least powerful and the oft colonized is scientific thinking. Powers as having poles or opposites, or being a unipolar center, or two poles or three poles. Power as being greater or lesser, as something being measurable, something yet again scientific. We see this understanding as well in how we try to balance power in the UN Security Council. And yet all of this falls apart quite quickly because power cannot be balanced indefinitely, but this scientific thinking tries to encourage us to see it this way. Instead, we see the stalemate in the UN Security Council being venerated as somehow the system working, the balance of power in action. And I would want to question the role of scientific thinking in this. This scientific reasoning to make sense of the political was also applied to the arena of the legal and the attempts to make politics more governable by governing the state scientifically, neutrally, impersonally, and transparently through the rule of law. For law was the goal because it's inherent of the reflection of reason and is opposed to this more savage political power. And yet I think threaded through both of these opposites, law and politics, or opposite organizing systems or disciplines, is a scientific reasoning. But maybe I should say more once opposites, for law and politics have, as a result of a thorough critiquing by CLS, no longer rightly understood as such. For while law might seek to rule impersonally on the face of it, we see the distribution of power entrenched, we see it embedded in a way to preserve the rights of the powerful in law. The UN Security Council being a classic example here, but perhaps even more importantly for what is going on around us today, the real failure of this balance of power is to be found in the NPT.
2 minutes, Gail.
No worries.
Yeah.
Can be found in the NPT, and the mad way states continue preserving power in this way. And so I think the book provides a number of fascinating reflections. The one thing I would maybe point out at the end, or the most frustrating way, was when we read the chapter, when we were reading the chapters together, was how we exercise powers of authors. And this was one of the core things that came up again. And now Martti Koskenniemi does say it was an embarrassing aspect of the chapters that practically all the characters are white European men. And he recognizes that we should be critical about the prejudice in the past. And I entirely agree with the idea that we must understand where ideas come from through an exercise of deconstruction to understand how tapestries are made and then disentangle them. And it's something I'm very aware of in my own work as I try to deconstruct where our understanding of international law spaces come from. I'm often centering the work of those I really do not want to be centering, where we continue to treat philosophers, these white men, these bricoleurs, like judges or like case law in our work. They continue to have authority and power over things that we do today. So why do we keep returning to these men folk? It's a very tricky question, and it's something I'd love to hear Martti Koskenniemi comment on. While in order to do this project of understanding where ideas come from, we must keep reading the histories of European ideas to unpick, to deconstruct, to understand where we are and how we got here. But eventually we also have to learn, or try to learn, about something else. And then we have to do something with that knowledge. And I think that is quite a daunting task. So thank you very much.
Okay, thank you, Gail. Iain, over to you, please.
Hi, I'd like to thank Martti for a very engaging talk and Gail for her incisive comments. I'm not going to be engaging so much with substance. I'm going to be a bit more methodological, and I just hope that my COVID Paul Robeson voice holds out for about 10 minutes. I want to say a bit more about the book than Martti did. I think it's a very erudite work, and I think that in his presentation, Martti only scratched the surface. I think it's an impressive, and much as I hate the word granular, a granular exposition of historical, religious, political, and economic factors which have played a role in the development of international law, but also the way it's been perceived. I think, you know, a lot of what Martti says in the work is about perception and the way that law is understood rather than the law itself. It also focuses, obviously, on the function that the legal imagination can play in this process, the way that lawyers and others, and as we've heard, at times they were theologians, attempt to engage with this use and consequences of matters outside the domestic national sphere by employing established legal vocabularies and categories which are often complemented by ideas drawn from other disciplines. Now, Uttermost Parts has already attracted a fair amount of attention in scholarly journals and also in scholarship. You know, at the conference Gail and I were at last week, where we were infected with COVID, one of the papers was already quoting it. So I mean, you know, it is seen as a major work, and by major I don't mean just, you know, a 1,000-page volume. It is seen as a major substantive work. It's been reviewed at length by my colleague Jean Dasmal in the Leiden Journal of International Law, where Jean argues that uttermost ends delineate spaces in which legal imagination has been exercised and which in itself constitutes a space where the legal imaginations of others may be exercised. This is probably a very bad paraphrase of Jean's argument, or the core of Jean's argument, and I should really apologize for that. I want to take a different approach. I don't want to engage with substance. I want to consider what I would call the rhetorical underpinnings of Martti's exposition of this mechanism of legal imagination, and then consider perhaps what might or might not be seen as difficulties which might arise with an engagement with imagination. And so I'm having to read this because, you know, I've got a COVID brain, and my COVID brain is much worse than Gail's. So I have to write things down, which I would normally not do because I'm just using notes. So I really apologize about this. It's going to be a bit rigid, I'm sorry. Now, Martti's account of legal imagination is based on argumentative, or what I would call rhetorical considerations. In his exposition of his methodology, I can see aspects of rhetorical theory which go back at least as far as Aristotle. Now, that should not be surprising, given that the book starts in the 14th century, which was around the time that Aristotle's work was received in Europe, and St. Thomas Aquinas tried to Christianize Aristotle. Having said that, I also think that the work reflects some aspects of more modern rhetorical theory, including at least an implicit rejection of Cartesianism, or rather the certainties which are demanded by Cartesian rationality. Now, legal imagination, I see, or my understanding of it, is the reimagining of legal doctrine or concepts or analysis through acts of persuasion. These acts of persuasion set up and contrast binary choices in an attempt to either shift or change the terms of the discourse in a way which is accepted by the intended audience. Now, in modern rhetorical theory, we would say that there has to be an act of persuasion which starts from a proposition which the audience accepts and tries to extend that proposition to a new conclusion which gains the adhesion of the audience. Now, as Gail said, Martti employs the idea of bricolage to describe the way in which these arguments are constructed. The advocate employs arguments which may be drawn from disciplines other than law, either to form or to buttress a hopefully persuasive argument which aims to augment or change the existing legal position. But to some extent, that argument will, or the exercise of that argument will be constrained by, if you like, the established legal position. In other words, there's only so far you can go. Now, I think what we're dealing with here in modern argumentation theory is the idea that we start, or this is the doctrine of inertia. We've got to start with a proposition which the audience already accepts, and then try to extend that argument into something new. And Martti argues that the way that we do this is by using legal imagination. He also, sorry, I've got to take another drink. That is not gin, it's water with lime in it, by the way. Or that it were gin, but we're not going there. No, Martti argues that bricolage begins at home, that advocates will draw on their domestic legal knowledge in order to see how that could be extended into the international sphere to cover these new situations. I've always had a problem with theories of rhetoric and or argumentation. When do you know that you've made or are constructing a good persuasive argument? To me, it always seems that this really cannot be gauged in advance. You might know that some arguments are bad and simply will have no traction, but it often seems that the evaluation of arguments is based on the idea that a good argument is one that succeeds. And that's an ex post facto evaluation. So, are there any factors that, we could fit in which might indicate, when an exercise of the legal imagination would have a greater chance of working or not? I also wonder, and this is maybe a bit unfair given the time scale of Uttermost Parts, but I also wonder if some of the base conditions for legal argumentation and legal imagination have changed in a way that might restrain the possibility of the function of legal imaginative, the work of legal imagination in the future. One of the things that I wonder is if some aspects of what we would call international law have now become more the law of legal regulation. And this, which makes Herschel-Lauterpacht's dogma that all international disputes are justiciable anachronistic. There could well be a number of, or a lot of international legal disputes which fall beyond law. Now, an example I'll give you is Alan Boyle's criticism of the notorious Southern Bluefin tuna arbitration, where he said that should never have gone to arbitration. It was about fish stocks. It really should have gone to a technical body rather than an arbitral tribunal. I mean, I wonder if that might...
2 minutes left, Iain.
Yeah, that's okay. I've got 1 point left to make. Okay, now, having said that, I think that Martti's exploration of legal imagination is impressive because imaginations can be difficult to fathom. Now, one of my favorite examples about this is about cats. And thankfully, this is not about the Andrew Lloyd Webber musical. It's rather an account by Robert Darnton, who's a cultural historian, who discussed an episode in the late 1730s when printers in Paris and their apprentices massacred cats, especially those owned by their masters and mistresses. Now, he comments that it seems clear that workers found the massacre funny because it gave them a chance to turn the tables on the bourgeois. By goading them with catcalls and provoking them to authorize the massacre of cats, they used the massacre to put symbolically on trial for the unjust massacre of his shop or his printing shop. However, torturing and killing cats was widespread in Europe at that time, at festivals, for fun, for whatever reason. But it strikes the modern reader as unfunny, if not repulsive. Our ability to get the joke that they saw in being really cruel to cats is maybe an indication which separates us from pre-industrial Europe. I think we also have a similar idea that we can be baffled by the idea that at one point animals were criminally prosecuted and as the result sentenced to death by formal courts. I think one of the things here is we cannot think that people in the past were just like us, but just maybe wearing different clothes in clogs, they understood the world differently and had radically different belief systems. But the investigation undertaken by Martti on the legal imagination, I think to a great extent transcends these conceptual limitations, and that's me finished, thankfully.
Okay, thank you very much, Iain.
How do I switch myself off?
I can give the floor to Martti, and then we'll go back to question and answer. Or I don't know how you prefer it, Martti. Or we can go back directly to question and answer, and you take it from there. I don't know which. How would you prefer? Do you want
I think it would be great to to give people the chance of posing those questions, and so let's go directly to the Q&A. And I've taken up a couple of points from both Gail and Iain. I'll come back to them later on then.
Okay, so I can see Rebecca. Yes, Rebecca, and then after John.
Hi everyone, and thank you so much for the fascinating presentation, and also to Gail and Iain for the comments. I have a very quick question. So you use bricolage, and it has been taken up so many times already by legal scholars to talk or to describe, to do a descriptive exercise of lawyers' work of legal imagination. And I was wondering at times, reading the book also in the Milk reading group, if it was not also a normative tool to describe or to go beyond description and point to what you think lawyers should do or should at least picture themselves as doing. Thank you.
Okay, thank you, Rebecca. John?
Thank you, Iain Kong, and obviously a great word of thanks to Martti. Martti, it's a great honor to have you speak here in Manchester and to deliver this prestigious Melland Schill lecture. Two quick questions from me, one pertaining to this notion of legal imagination. I mean, you present your book as a history of legal imagination, and all our discussions so far today have been about legal imagination. And my point is, why is it a legal imagination? Why is the imagination we are engaging with illegal? Or why do we need to label it as belonging to the realm of the legal? I mean, in the book, you're quite keen on saying that it's not the protagonist that make this imagination, this exercise of imagination, legal. You also dismiss the context as providing a legal character to this exercise of imagination. You say it's the legal vocabulary. But why is the vocabulary in which these merchants, these theologians, these lawyers engaged in, why is it specifically legal? I mean, precisely the imagination they indulge in is very often about unmaking the disciplinary boundaries between vocabulary. So why calling all this legal imagination and not just imagination? I mean, does imagination know disciplinary boundaries? So that's my first question. The second, and it's a more personal question. I mean, I remember us meeting in Birzeit University a dozen of years ago, and you were already presenting some of the insights from this work. Obviously now you've completed it. You've completed what is really an amazing, impressive and stunning piece of work. So my personal question, more as a scholar and a friend, which is, what's coming next? What's the next project?
Okay, thanks, John. Shall we take one more, Martti, and then you? Okay, so I can see, yes, Susan, is it Susan Savoy?
Yeah. Thank you, Professor Koskenniemi, for this. And it's such an honor to hear you and to be part of this talk. So my question to you is, like, when can we save legal imagination from the political imagination's predestination? So I was thinking, because when in the conclusion of your book, you wrote, like, this is about the history of legal imagination and not the history of international law, because this is precise, as international law was constantly being shaped by global politics, and so is it even today. So when politics can dictate law, reshape it, interpret it, and make laws void or voidable, can you comment as to where the sanctity of legal imagination lies for the future? For like, when we look, as the professor was like saying, like when we look to the future, where do we see that sanctity of the legal imagination lie? Is it in the consensus or in the will, like in the narrative of assertion or power? So I would be happy to hear your thoughts on that.
Yeah, thank you, Suzanne. So the floor is yours, Martti.
Okay, well, there's a lot of stuff on the table now. So let me take Gail's point first, and let me start by saying to Gail that I wish I had heard her speak earlier on. So this distinction between bricolage and technology, or engineering, bricolage and engineering. That's a wonderful distinction, and I'm going to use it every day now from now on. I think so. So you've captured something there, and it was the first time that I met up, obviously, with this distinction. And let me just say a few random things quite rapidly on it. So the first thing is that I do feel, on the basis of my own experience as a lawyer, that the sense of bricolage is much more prevalent. So if engineering presupposes a system, engineering presupposes a series of technologies that relate to each other in some predetermined way. Engineering is a very systematic activity. Engineering is reproducible. And I didn't feel that legal activity, counseling, is like that. So counseling is determined on the one hand, of course, with the task that you have. So what is the substantive question? But on the other hand, it's determined by the time you have available. And the time is never sufficient for really reflecting and putting all the mechanisms at work. So you have to do what it is that you have to do in a situation where you know it doesn't suffice, that the answer will be stupid. So confession, I've been reading a lot on confession, and I feel that the task of the confessor, the subjective experience of the confessor when he then needs to provide absolution in a really short period of time. So what is the crime, or what is the sin? What quality is the sin like, etc. So that's very close to what lawyers do in my experience. And then, of course, there is what you suggested, what was underlying your suggestion, which is that engineering is technological and tends to presuppose a mechanistic system where maybe technical knowledge and instrumentality predominates over feeling and persuasion. Because I think that law has to do with persuasion. I feel that bricolage goes closer to that kind of performative situation than engineering. But I thank you, so that's great. So I'm never going to forget that. Then there's the question of white men, so Kant and all the rest of these dead white guys. So why do you come back to them? So the easy answer is that, well, I suppose when I came to the idea that imagination starts from home, I was thinking of myself too. Here I am in this study of mine. You know, you look at the books there. So this is my home. And who are these? Who wrote these books? Well, these men wrote this book. So I had some limited amount of time to produce my performance, the performance of this book, of mine. And so I go to do my bricolage with these works that are over here. So that's a kind of a flippant response, but it's also meant in a serious way. So somebody's told me that, why don't I bring out the voices that are always silenced? by the way, I have a little bit of a reluctance of using that kind of terminology. But I hear that often. So there are silenced voices, and you should give voice to those who haven't received that voice earlier on. And I feel, who am I to take up that voice? And wouldn't my taking up of a voice of somebody whom I don't know, whose life experience I have no realization of, who am I to take up that? And isn't it in some ways even a worse violation for me to pretend that I have this universal character that can, appear in whatever guise, wherever. And so, by way of apology, but also seriously, I say my imagination starts from where I am. And of course, I also feel you take from these white guys whatever you think is useful, and you dump the rest. And I've dumped a lot of white guys along the side of the road. So there. Iain, so you started out by asking, or saying that this is how law is perceived, it's not how law is. Well, I don't make a distinction between those two things. So the law is how it's perceived. I don't know. I've never witnessed law in its magnificent being as it is. I've witnessed people perform law in various ways, written ways, oral ways, etc. So I don't make that distinction. I agree with you that, and that's a very perceptive very accurate perception on your side, that rhetorics and performance predominates. Yes, they do. So all over the place. So I am a rhetorical person. So I want to write in a way that has some rhetorical power, but I also think that law is about persuasion, rhetorical persuasion. But when I think about persuasion, and I want to be very clear here, I've had this conversation sometimes, that I'm not thinking persuasion in the Habermasian mode. So I don't think we are in a universal pragmatics. So I don't think people are persuaded by the good argument. I think they are persuaded by authority. People yield because somebody is in the position to speak authoritatively on something. And then you yield. You don't analyze the argumentation and situate it in your frame of recognition or frame of reference in your own mind and see what fits, what doesn't fit. You yield because there is no time to continue argumentation, or that you will be worse off if you even try. Million reasons for which people yield. So when I say law is about persuasion, I don't mean persuasion in a rational sense. I mean in the same group of associations that the word bricolage creates, really a messy world in which we bring out our power as persuaders, and in which we yield in our incapacity to resist any longer. Yes, Rebecca, bricolage, is that a normative standard? Yeah, it is a normative standard. So I want to liberate lawyers from thinking that in order to be good lawyers, they have to be really brilliant philosophers. And they have to know social sciences and economics and psychoanalysis and all of these things that are being pushed to law from all around, and in which my academic colleagues often excel. But when I think of the lawyers that I've met, the good lawyers that I have appreciated, that have sometimes really stunned me by their ability to associate things and dissociate things and imagine things into existence, I think, well, that's a wholly different way of operating than thinking in philosophical, technical, or whatever terms. So I think, in that sense, the bricolage has a normative quality to it, although I feel that I wouldn't want to write it down in a series of propositions about what it consists of and what everybody needs to learn in order to be a good bricoleur. I hope that's a sufficient response. The main point, however, is to say lawyers that to be a lawyer is not to be a philosopher or a sociologist. It's just, you know, to in the limited space of time with the limited materials that you have available, create something magnificent. That is to say, something persuasive, something to which other people have to yield in some pragmatic sense. Jean. So why legal imagination? What does it take for something, an imagination, to be legal? I have a very simple and clear answer. So words come before thinking in my world. So vocabularies are prior to consciousness. We come to, so an imagination is legal when it operates with a legal vocabulary, when it yields to thinking in terms of and performing in terms of vocabularies that are imagined as legal. And then so in my world, it's always a little bit more law that speaks than the person who speaks to law, although the person then operates there as well. It's an eccentric variant of Marx's people can do whatever, but you know, in the conditions given by their or within the limits of the conditions in which they are born. And so legal vocabularies limit things people can do, although they can do many things with it. So to me, it's a linguistic affair. So so that's so much. And then your second question, what's next? What's next? Yes, well, but I don't know. I don't know. Do I have to answer that question? So, I mean, it took me 15 years to write this damn book. So what next? Now I am enjoying a situation where, you know, I'm a man without a project. And so offer me something, suggest to me a nice thing to do. But I want to, more serious, I think my ability to attempt to operate critically with history has now been exhausted. And I don't see, when I see the expanding historical writing out there, I see that critical ambition has fallen away from much of that writing. It has become, well, it's a bad word, but antiquarian in some sense, disciplinary history. So fulfilling the holes in the story about international law or whatever, and that we can do that. So it's a puzzle, and you know, you can always, there are always holes that and you can find, but I don't think that I'm going to do that any longer. I might metaphorically refer to some of these events or persons that I've learned, but no longer a historical argument. Susanna, it was a complex argument, a complex question that you asked about the sanctity of legal imagination, especially, I suppose you were suggesting sanctity of the legal imagination in contrast to political imagination. How can one? Well, I don't share that sense that it's of its sanctity. I don't think it's sacred in that sense. I have great admiration to political persuasion and to people who dwell in political activity and are political counsel for politicians and so on. So I have, of course, in my previous writings, I have worked a lot on the relations of law and politics. And many of my students have seen the duck rabbit with which I try to illustrate my own sense that these are both two vocabularies that look at the same world. And like every vocabulary, they show us some aspects very clearly, but they do that at the cost of leaving other aspects of the world hidden. And so I think in order for us as individuals to be to operate in the world intelligently and to attain the good results that we wish to attain, we must be able to operate with many vocabularies, because each of those vocabularies shows us some things that the other vocabularies do not show. And the world is a complex kaleidoscopic place where we need to understand the world from many sides. Political understanding has its merits, although of course politics too can be formalistic and instrumentalized and just plain shallow, just like legal imagination can be as well. It's like ducks and rabbits. So the same world can be described in different ways. There is no intrinsic priority. Neither one of them is more sacred than the other. But once you are in one, once you are in law, then you have to be able to, in order to carry out your legal thing properly, you have to be very powerfully engaged in the very legal quality of the law that you operate with, and forget about politics, because the more you insert political things over there, the more it all starts to sound like, alkaa kuulostaa siltä niin kuin mä puhuisin suomea. The more it starts to sound like I will start to speak Finnish in the middle of an English sentence, nobody will understand me, and it doesn't operate that way. So both politics and law are complete wholes in this way, but you have to change sometimes from one to another. Yep, that's it, Iain, for responses.
Okay. Thank you very much, Martti. I don't see any hand, but my own is just a kind of very brief questions, which is really about how, I mean, you did talk about that, the interdisciplinarity of how this imagination has happened. So my question is, how much do you think, say, economic and sociological events actually shape this legal imagination the way you've written it, or maybe you didn't even think it in that way? I see Iain.
Iain, there's a question in chat.
Oh, okay. Yes, please, go ahead, yeah.
Do you want me to read it out?
Yes,
well,
yes.
I was going to ask if Chris wanted to unmute himself and ask the question.
Oh, sure. I really didn't want to take too much time, but based the sort of summation of what I've been hearing so far sounds a lot like what some disciplines or some groups would call code switching, in terms of like the change in vernacular. And I just wanted to draw that link, speaking of the value of that practice.
Okay, thank you.
So should I respond to Iain and Chris?
Yes, please.
Just very briefly. So economics, social understandings, etc., they intervene as part of our understanding of the world. But then when we respond to that understanding, we respond to it with law. And when we are, and so this is something I have over and over stressed, especially with students, that when we do law, we do law. And that's it, but we do it in social contexts. We do it in contexts where human beings operate in the psychological structures, within the psychological structures that determine how they operate, etc. But law is law. And so, and as I tried to make the point by speaking Finnish in an English sentence. So if you go to well, let's make it a real story. So I was the legal advisor of the Finnish UN delegation sometime in the 89, 90. I was posted in New York in the Finnish mission, and Finland was in the Security Council, and I was there sitting there. And my ambassador, who was a professor of political science also from the University of Tampere, a really brilliant guy, and he often consulted me on the UN Charter. And it was clear to me, and he pointed out that I was an acceptable interlocutor to him, because when he asked me a legal advice, I just told him what I thought was the best legal position to be given, instead of trying to say to him, well, actually the Finnish interests would go in this way, or actually we might want to better for the world if we did in that way. And he always said that he dislikes those lawyers who kind of become in his company political decision makers. So what he needed, he was my client in a sense, and what he needed from me was a legal advice. And then he either followed that advice or didn't follow that advice. He knew that he was capable of doing that. But he had a hard time with those lawyers who feel that they can kind of mix within their law all kinds of economic or social points. So, and so I press upon my students, and especially my most critical students, who always come with this idea that they should be half talking law and half politics, that no, you should just talk, if you want to be persuasive. And I want you to be persuasive, I would say to my critical colleagues, because for obvious reasons. So you need to be a really good lawyer. So that's what you need to be. And so Chris, code switching, of course. So I'm very influenced by Niklas Luhmann's systems theory. And I think that systems such as law and politics, or within law, systems such as environmental law, human rights law, criminal law, do not really mix with each other very easily. Luhmann uses the verb, at least in the English translation, to irritate. So these systems interact only by irritation. And so because otherwise they can only adopt to themselves only things that they already know. And so they tragically remain separate, always repeating over and over again what their own system allows them to produce. And they can interact with another system to the extent that they recognize in that system the qualities that their own system already has. So nothing changes, apart from this thing that he calls irritation, in which there's a disturbance in the system and something might or might not happen. I don't want to push that too far, but I think that there's some really useful insight in that.
Okay, thank you very much, Martti. I don't see any hand up. It's only left to me to say thank you so much. I wish I could be saying we'll go for a drink afterward, but we can do a Zoom.
Yes.
Yes. So I mean, hopefully we'll be able to organize this. But it was really an honor for us to have you here, and thank you for your very, very.
Sorry, there's a hand. There's a hand.
There's a hand.
Yeah, look.
Oh, no, it's the clapping. That's I suppose. Luke, is your hand up? Oh, thanks. Yeah. That's the reaction of the Zoom reaction. That because we cannot do it physically, we have to do it with the icon or whatever you call them, emoji. Yes. So okay. So thank you, Martti, and have a good weekend. And we'll look forward to seeing you soon.
Thank you, Iain. I've enjoyed this. I look forward to returning to Manchester. It must be 15, 20 years maybe since I was there. I enjoyed that 2 days though, and I look forward to being able to travel later in this year. I think in May, I have my first tickets to go anywhere in 2 years. So I really need it, and I think everybody needs it.
Yeah, no, that's true. Yeah, no,
thanks
definitely. We'll have you, if not this year, next year. Thank you. Yeah,
right.
Thank you.
Thanks. Bye-bye.